they've created this panic, and landlords are panicking, investors are panicking because they feel that they're going to be limited to what they can do on their investment.
The second that comes into play, that 12-month window is just going to be absolute carnage for tenants.
Fines are going to be upwards of £30,000. So if you like playing with fire, then this could be just the piece of legislation for you.
You know what I'm going to ask here, and you can say no and nod at the same time. Can I serve the notice, say my grandparents are moving in, and then they never move in?
Okay, everyone, and welcome to an episode of the Investors Corner. Delighted to say that we're joined by Liam today, and we're really going to get stuck into some fine details on what landlords and anyone that's looking to invest in property need to be thinking about over the coming years, shall we say. But Liam, when I was doing a little bit of research before this podcast, I stumbled across one of your clients, actually. And this is what they said to me about yourself. In the films, if you're in trouble, they call Batman. In real life, you call Liam Connelly.
Oh, no, they didn't.
So tell us a little bit about what you do day to day.
Well, I live in Wayne Manor. No, I'm a dispute resolution solicitor, and I deal mostly with landlord and tenant and property-based claims. So if it's affixed to the ground and you can have an argument over it, then I'm probably the person that you'd want to talk to about it.
Do you have your own sign?
I wish I had my own sign. I'm going to have to invest in that. We'll see whether the firm is willing to put some proper money into it.
I'm happy to get involved in financing it, just for the social content.
Yeah, absolutely. Yeah.
Love that. So, Andy, I know you were keen to really get stuck into the finer details of this today. So, in terms of what's going on and what people need to be thinking about, thank you for coming in. Thanks for
inviting me.
No, you're very welcome, and thanks for putting a bit of effort and time. Not all guests put as much effort and time in as a PowerPoint, which no one needs to see, but just to make sure that the facts and the figures and the prompts are there for you as well. So, what is going on in general for landlords that they're maybe not thinking about that they should be?
So, as long ago as 2019, Theresa May said that we should think about abolishing Section 21, and everything that's happened has been a really long time in the making. We've had a white paper last year where they talked about what change might possibly come. Anyone who's interested in looking at it, that was produced in June 2022, and it's called A Fairer Private Rented Sector. That was the white paper. And we've got some draft legislation now. So we've got a draft Renters Reform Act bill, and that is basically going to bring in, or proposing to bring in, significant changes to how the rented housing sector is going to work going forward. And I've put together a few slides really to prompt me more than anything else on what the main changes are that people can expect to see, because there is an awful lot that's in the bill, and there are a lot of things in there that are in there now that probably won't be in there when we see a final bill, if we ever see one.
It shows how hard it is for general public, private landlords looking to get into it, that, between the four of us in this room, bearing in mind the professions that we're in, it's not something you could just roll off the top of your head. So what chance do the property investors and the landlords out there have to remember it? That's why we do these podcasts, and that's also why there's people like yourself and obviously Mike, Andy and me trying to really make people aware of it, because it's not easy, is it?
No, it's not. It's really extensive, and I've just picked on a few of the main points to talk about for today. If you're having trouble sleeping, you could print off a copy of it, take it to bed with you, and I guarantee you'll be out like a light within about 15 minutes. So
how long is it?
Yeah.
How many pages?
Oh, goodness knows. It's a lengthy bill, and you would expect it to be for the sorts of changes that we're talking about. It is going to be a big difference.
But the main problem is landlords have been forced to guess what's going to happen for 4 years now, and an untold amount of time still before anything happens.
Well,
so people with property, it's reasonably illiquid as an asset. So people are having to make decisions based on not a lot of facts.
That's right. And it's still got a long way to go. So it's still got to go through the House of Commons. It's still got to go through the House of Lords. You can expect to see changes to it. It will be redrafted several times. There will be things that are in there now that won't be in the final bill, the final piece of legislation. And we also don't know what impact a general election will have on any of this. So if we have a general election, will this policy or will this legislation see the light of day? I suspect it will, but we still don't know what
A version of it, maybe not this
still,
exact version.
Exactly, we still don't know.
And that's what I say
it's gonna
to
look like.
clients at the moment, that it's not going to be the final version. So they've created this panic, and landlords are panicking, investors are panicking, because they feel that they're going to be limited to what they can do on their investment, which might be the case. But right now it's don't panic, because nothing is sort of set in stone, really. You've got like you said, it's got to go through a timeline, it's got to go through various different stages, and it might be 2025 before we see anything sort of set in stone, really. So I think one of the biggest things that I saw panic on was about the Section 21 notices, which I'm sure you've got a slide on.
I think that might.
Is that the first one?
That might be.
Number one.
There you go.
That may be. Well, be
I feel
the
like
first
it's like
point.
something like the top of the pops. In at one this week with Liam. Let's go.
But you can't. I mean, you can't get rid of something like Section 21 and it not be the main point.
Yeah.
So for anyone not familiar with it, Section 21 is the basis of a no-fault eviction. If you have previously complied with everything that you needed to comply with as a landlord, you can serve at the end of a term your Section 21 notice, and you can expect your tenant to vacate the property. If they don't, you can take possession proceedings, and a court will have to grant a possession order. It's a mandatory ground. There doesn't have to be any fault. They have to go. What the legislation will mean is bye-bye Section 21. There won't be a no-fault eviction process anymore. It will be completely gone. Landlords wanting to take possession are only going to have available to them Section 8 of the Housing Act, and it will be an extended Section 8. So I can talk about that in a bit more detail when we get to it. But the rationale...
Why would that? What's the logic from Theresa May to want that to be evicted? Can we explain that?
I can produce a quote. I've got a quote.
I love a quote.
I've got a quote
like
as
my
to
Batman
why.
quote. I like others too.
Their reasoning why, the government's reasoning is removing Section 21 will level the playing field between tenant and landlord, empowering tenants to challenge poor practice, as well as incentivising landlords to engage and resolve issues. Now, I'm not sure that answers the question at all, really. In terms
Not sure
of
it levels the
why
playing
they're
field
doing
either.
it. No, I would probably say it weights it certainly in a lot more towards the tenant. I certainly do think it's good to drive a balance where everyone's looked after in a fair way and there is equity of arms in some way. But maybe this goes a little bit too far. If you look at what Section 8 is going to have in it, or if you look at how the process is going to work, should I say, going forward, landlords aren't going to have a right to say to a tenant, right, I want you to move on now. I need the property on a no-fault basis. But tenants are going to be able to still serve notice. I think 2 months notice is what we're talking about. So they will be able to move on relatively easy, but a landlord won't have the same reciprocal right to say, well, I want my property back on 2 months notice, which is what we used to have under Section 21. So what we're going to have instead is a much wider Section 8, and that's what they're proposing, which will, I think, mimic in some ways what we've got with Section 21, but it's still a lot more complicated. What I would say to landlords who are worried about it is that there is going to be a transitional phase to all of this. It's not going to suddenly happen overnight. And even when the legislation is passed and it becomes statute and it's enshrined in law, Change is going to be implemented in 2 stages. So I've made a note of those here. 6 months after the Act is introduced, new tenancies will not be allowed to use Section 21. So you're still going to have 6 months for any new tenancies created after the legislation is passed. In terms of older tenancies that are passed, that are created before the legislation goes through, you're going to have, and I've got it in inverted commas because it's not clear from the legislation what it's going to be. It says at least 12 months later, the older tenancies will not be able to use Section 21. So if you've got a current tenancy with a tenant and you want it back after this legislation's passed, you're going to probably have, from the date that this legislation goes to, at least 12 months still to use your Section 21 notice. And the same goes for newer tenancies, but you have 6 months instead. So it's not panic stations just yet. You're still going to be able to do those things if you suddenly decide this is too much for me. I'd like my property back and I'm going to sell it. You're still going to have the option to do it. The new legislation doesn't suddenly mean overnight you're stuck with your tenant.
Which I think a lot of people think that once it's introduced, it's going to affect them straight away.
Yeah.
So what you've just said there is, there's no panic to it, because if your plans change at that point, then you've still got a period of time where you can serve notice.
You're still going to have that transitional period.
Yeah. I just think back to certain catalyst moments in the property market dating back to when I started in 2003. And I think of things like when the 3% stamp duty additional came in for landlords. I think about stamp duty holidays that have come in as well. And I now think about that, and I just see the second that comes into play, that 12-month window is just going to be absolute carnage for tenants as well. Because
worse for tenants.
Worse for tenants. They're trying to level the playing field. You've just evicted half of the tenant population in the country overnight. Is the facts of what will happen.
Yeah.
Because I will on my property. Because I'm looking at it from my point of view, thinking you've just removed the ability for me achieving my goal of purchasing that buy to let.
You've certainly made it harder.
Yeah, because most people have got it with the sort of almost pension fund type scenario, the long-term game. And if the goalposts get moved from the landlord, that potentially you're not going to be in the position you would like to be, and it's not as clean cut as it was before, we just bring it forward and you just look at that equity, that cash being put into a different investment that potentially gives you more control. Because now as a landlord, with something like that coming into play, the amount of control you've actually got over your own property, it is yours. It's not the tenant's. It is your property. You own it. By land registry, you own that title. Is all of a sudden just being like whipped away from you. I just think there'll be an onslaught of landlords serving notice to their tenant and inevitably selling, which is the absolute last thing we need in the property market at the moment, is more landlords selling.
You may well. I have spoken to lots of people who are landlords, and I have told them about what's coming and what's on the horizon, and it is frightening for a lot of them. So I can completely understand how you would feel personally about it as well, because it's how a lot of people are feeling. If you make something more difficult and you remove a right that you've had before, then naturally people are gonna be spooked by it.
So you've just convinced Ian to sell his rental portfolio, Liam. Scared the crap out of it.
Sanjay, let's get a beat the portals going.
Ian's read the newspaper headlines of Section 21's been repealed and he can't have his house back. What's the counter to it? What's the don't worry because?
That's a good question, Mike.
Trying to be positive.
Well, Section 8, as I mentioned, will be extended. So previously there was an old ground, your grounds for possession when you're serving your Section 8 notice are basically set out at Schedule 2 of the Housing Act, as you will probably know.
As you well know.
And at the moment, it lists a number of things that you can rely upon that you can put in your notice. That list of things is going to be extended and it's going to be adjusted so that you have more grounds, or some of the things that have infuriated and frustrated us in the past are different and are being changed so that they work better, or in theory they will work better. We'll have to wait and
These
see.
are discretionary grounds.
We'll have to wait and
we
see if we
on.
do. So currently there's a ground one where a landlord, if they give notice at the beginning of a tenancy that they may want the property back at some time to live in it, they can take the property back. And that you would rely on that in a Section 8 notice. You'd say, right, I want the property back because I want to live in it now. They're going to extend that. So landlords will be able to give notice if they or close family members, and that would include grandparents, siblings, grandchildren, want to move into the property.
So if I'm moving overseas for 2 years
Yeah.
on a work visa from my own main house, renting out my main house, which happens a lot in the home counties, in theory, I can serve a notice before I go to say, this is my main residence, so I'm going to be taking this property back at some point.
If somebody's going to live in it, if you want a family member to live in it, someone who's close to you, grandparents, siblings, grandchildren, that sort of thing, your kids, then yes, you can. There's no notice requirement anymore at the beginning of the tenancy. You don't have to say anymore, I might take it back for this reason, but it can be a reason later now. So you can say, I want it back because I want a family member to live in it, and you'll be able to serve a notice and you'll be able to take possession on that basis.
That's grey area, because you know what I'm going to ask here, and you can say no and nod at the same time. Can I serve the notice, say my grandparents are moving in, and then they never move in?
No, you can't.
Are you
do
nodding?
That. You could, but there is a prohibition from immediately reletting it to somebody, and the fines are going to be upwards of £30,000. So if you like playing with fire, then this could be just the piece of legislation for you if you enjoy life on the.
So your tenant could keep a close eye on you and see the property being relet.
Could,
and therefore call the tenancy police.
We'll have to look at how the legislation plays out on that, because the wording is, well, you can't immediately relet it. So
if they've been specific in
new kitchen
how
goes
long
in.
Who knows how long?
3 months, 6 months.
It could be 3 months. It could be 6 months. Right. I don't think it's meant to be a blanket ban on you ever letting the property again.
Yeah, I want to know who the tenancy police will be.
Yeah,
are they the same as the board police?
Same as the EPC police? Yeah, I'm confused to all of these things.
Well, there'll be a new ombudsman, which was one of the things that I was going to talk about later. They're going to introduce an ombudsman that's going to specifically police these things. The findings of the ombudsman that a landlord or tenant can refer a dispute to will be binding. So if there are disputes in relation to how the tenancy is working, whether or not someone is complying with their obligations, then you can refer things to an ombudsman. They will have powers to also issue fines. I don't think it's going to replace the court system. So I think a scenario like this one, if a landlord says, well, I'm going to let to a family member and then doesn't and takes the property back, I can see that being a scenario that would have to be probably determined by a court in terms of whether or not that person's been evicted.
Liam and Mike should run that ombudsman.
Yeah, you can imagine it, can you?
I'd love to be a fly on the wall in the conversations.
Mike the bad cop, Liam the good cop.
The one thing I know is we're going to have another bill every year for a membership as a business.
Yeah.
For another ombudsman. Can't wait for that.
Well, yeah, very possibly. It's going to be landlords are going to certainly have another bill, because you're going to have a process now where you will have to register your tenancy, and that's mandatory.
Yeah,
and if you don't comply with that, there will be a fine. So I'm probably jumping the gun. That's definitely on a later slide.
We have a habit of doing this with our questions. Yeah. We like to confuse the order of the guest points.
That's all right. Back to the possession grounds. So Section 8 and its extension, there's going to be a new ground 1A. So we just talked about ground 1 and how that's going to be expanded. Don't worry, I'm not going to go through all of the grounds. There'll be a new ground 1A, and basically you will be able to obtain possession where you are intending to sell your property. So that gives you at least some comfort as a landlord. It's not the case you're granting a tenancy to a tenant and you can never then dispose or deal with your property in any specific way. The tenancy will have to be at least 6 months old before you do it. So you can't let it to somebody and then say, oh, I've decided I'm putting it on the market now.
Again, so it's just like a Section 21 in that,
So
in that
it
standard.
would be,
you give minimum 6 months security to a tenant.
and there will be a 2-month notice as well.
Sounds
just
familiar,
like
doesn't it?
Yeah.
Ian, are you
like,
okay? Are you
the
keeping
heart
the
rate changed
portfolio?
your mind.
The heart rate's back now. So basically, we're just throwing a few different numbers around. We copy and pasted from Section 21 that line, and we just slotted it in an 8, basically.
It's a 1A now.
Yeah, okay.
Keep that in your mind. Tattoo it on your arm. 1A.
But in summary, for layman's terms, for anyone that's listening like me that just wants it kind of dumbed down a little bit, what we're now saying is you can still evict your tenant if you want to sell. You can still evict your tenant if they've been a bad tenant.
Yes.
But if they've been a good tenant, then they've got a right to stay there longer than the tenancy agreement.
Yeah. And most tenancies where the tenant is a good tenant, the landlord doesn't really want to remove them and doesn't have any interest in removing them. The main consequences that I come across, or the main circumstances rather I come across, where a landlord wants their property back is because the tenant is either being very difficult or they're not paying rent. So if you've got a good tenant, you're probably not going to have those circumstances where you want the property back, unless you want to either have a family member live in it, or you want to live in it yourself, or you want to sell it. So it may be that in practice, our extended Section 8 doesn't really change very much.
Yeah.
The other warning I would say for people who are thinking about, well, what if I just say I want to sell it? And then I serve a notice.
I was just going to come on to that.
I didn't want to be that guy who said only 50% of houses that come on the market to sell actually sell.
I think you would probably have to show your firm intention that you wanted to sell it. Or there will be a risk to you.
Yes.
If you decide, well, I'm going to say I'm putting it on the market, I'm not. I mean, that would be obviously incredibly dishonest, and you'd have potentially a big fine again.
Yeah.
The risk to the landlord to that as well is you've got a vacant property.
Yeah.
That's costing you money or not making you money, depending on what your
common sense says that you're going to have to put 6 months in between. If you remove a tenant for that reason, then relet it, you're going to have to put a 6-month gap in, aren't you? To say, well, I tried to sell it, it fell through multiple amounts of time, and now I'm having to take action, which is, a fair period of time, isn't it?
Exactly that. Serious antisocial behaviour. Currently, it's 4 weeks' notice. That's going to be reduced to 2 weeks, so that's good. That would be another ground on which you could get possession of your property. There's going to be a new ground 8A, and I think this is a really good one. Previously, we've had ground 8, which you might know about or might not know about. So, where a tenant has a obligation to pay rent, it's monthly, they're 2 months in arrears, that's a mandatory ground for possession. And you serve your Section 8 notice. If you get to court and the tenant is still in arrears, 2 months arrears, then the court has no discretion. They have to grant an order for possession. Now, previously it's created a slightly frustrating scenario where a tenant, just before you appear at court, pays the arrears. And so you go into court and you say to the judge, I can't say to you anymore that there are 2 months arrears of rent because the tenant has
paid £1,
has paid all of the arrears, has completely cleared them, or has brought it below the 2-month level. So you're then at a stage where you're relying on discretionary grounds if you put them in your notice, which you should do in every circumstance to avoid that possible disappointment. Now, this ground 8A is going to change things because it basically says you can issue a notice to tenants who've been in at least 2 months of arrears on at least 3 occasions in 3 years. So it can be used if a tenant is not in arrears at the time of the court hearing. So if that's proven, landlords will only need to provide 4 weeks' notice, and it will be a mandatory ground. So if there's a history of late payments, and it's 2 months of arrears on at least 3 occasions over 3 years, that will become mandatory, which would be a lot better
It's very
than
sensible.
the current ground 8 that we've got in place at the moment, which can be really difficult and can leave landlords relying on, well, they're sometimes late or they're persistently late in paying, which were all discretionary grounds. So a court has a discretion and can say, well, there might have been a good reason for that, which is fair enough, I think. But this is going to be a lot better.
Ian, heart rate monitor, how are we? Where are we? Are we now below
The
where we
Garmin's
were?
all
Are we now
right.
more
Yeah.
confident?
The Garmin's all right. Yeah. I've cancelled the Beat the Portals with Sanjay, and we're back in the game.
So that's good. That's good.
The reason why I said it though is because let's profile a classic landlord.
Yeah,
here.
absolutely.
And the classic landlord has an element of control freak in them. Typically, you know,
yeah.
we've got the best part of 60 years worth of experience as estate agents, letting agents here. You will have dealt with numerous landlords. There is an element of control freak in a lot of landlords. If you profile them, it's not a bad thing. It's, you know, you get that in senior levels of management and things like that. And what that felt like at the beginning is the control was being removed.
Yeah.
Now what we're seeing is actually there is a little bit of common sense and logic that's being put in there as well to kind of almost go, right, this is void, but this is the common sense that's coming in, which is great. And, you know, I appreciate you putting the time and effort into explaining it.
Yeah, I think it's a case of, well, this is void, we're not doing this anymore. It gives people a bit more certainty in terms of how long they can stay, that you're not going to pull the rug. But it also looks at the common reasons why people take possession proceedings. And for me, the most common is they're not paying rent. And in the past, people have managed to avoid possession orders by paying at the 11th hour and then just relying on discretionary grounds. That's not going to be the case anymore if this goes through. It remains to be seen whether it does. And it's sensible. I do have some worries about it and the way that these things are going to work going forward. So it's every tenancy that's going to be created now is going to be a periodic tenancy. There's not going to be a fixed term tenancy anymore. It's not going to be the case that you can say, well, I'll let this property to you for 6 months or I'll let it to you for 12 months. It's going to be periodic. So if you pay rent monthly, then it's likely it's going to be a monthly periodic tenancy, and you're not going to be able to just easily determine that anymore. I do wonder what the knock-on effect for something like that, for example, student letting might be. So you let a property to a student for a year. What happens when the student gets to the end of the year and decides they don't want to leave? Have you not then just damaged the available housing stock for students?
That's an incredible grey area, because we're talking about, well, you only want the house back because you want to sell it, this, that, and the other. But student housing, that's not the case. No. You want the house back over the summer to
let to new
sling
students.
Some magnolia around and then re-let.
Yeah. So it remains to be seen. I think they have to rethink that. I've seen a lot of comments along those lines, and I think they will probably be alive to it by the time any legislation is passed. So short-term student
good use
letting.
Of probably. Yeah.
Probably. Well,
we've got to go on here. What are the other key points that's in the bill at the moment?
So other changes, you've got tenants are going to be allowed to keep a pet with the landlord's consent, and that consent is not to be unreasonably withheld. So that is
fair.
So if we're saying that if they've got a leasehold property and there's something in the lease to say that they can't keep pets at the property, that's a reason why they can't have a pet in that property. But if they haven't got anything like that, then they request it.
Yeah, going forward now, a landlord's not going to be able to unreasonably refuse a request from a tenant to keep a pet at the property.
Depends if reasonable means common sense,
yeah.
or whether there's a reasonable For me, if I'm renting a 1-bedroom house and the tenant's got 4 German Shepherds, it is reasonable for me to turn them down
to say
on the basis this property
got...
isn't big enough and doesn't have facility for you.
I have to have a look at it, but I think it says a pet, which sort of suggests singular rather
Interesting.
than
that's a great one.
But
nothing like a loophole in the law, Liam.
I'd have to have a look at that in a bit more detail.
Which goldfish is going to get the toilet?
that can't be right. So I'll have to have a look at that again. But tenants are going to have a policy of insurance in place, so that's something that's helpful. That maybe gives a bit of
Oh dear, I lost
peace
it for a
of
minute then.
mind.
I was thinking about referencing goldfish and stuff like that. Let's get back in the room.
So in terms of other things, I've listed just a few of them. So I still come across, I don't know why I do, in 2022, a scenario where landlords have let a property to a tenant without providing a tenancy agreement or any written statement of terms whatsoever. That's going to be changed. A landlord will now have to provide a statement of terms and information to a tenant before the commencement of a tenancy. Again, if you don't do that, you're going to be fined. I think the maximum fine is £5,000 for that. We mentioned it before. Tenants will be able to provide 2 months' notice, expiring at the end of a period of the tenancy, but you can agree shorter periods if you want to. So that's fair enough. We talked about the landlord portal and ombudsman. That's going to be introduced. Membership of that's going to be mandatory. Again, fine up to £5,000 if you don't register the tenancy that you have. The ombudsman will have the power to award up to £30,000 in compensation to tenants, and the decision will be binding. Rent review is another one that I wanted to just briefly flag. Landlords are going to be restricted to 1 rent review or increase per year. And the notice period for that has been increased to 2 months. Doesn't mean it can't be challenged. Tenants can still challenge that in the first tier tribunal if they think the rent is too high.
Okay.
Is there anything else? Deposits. I think probably worth talking about deposits. Section 21 is going away, but that doesn't mean the stringent requirements of deposits is going on. Now, previously, if you haven't been very good with your paperwork and you haven't properly protected a deposit and provided the tenant with the prescribed information that you're supposed to provide to them within 28 days of registering a deposit, you wouldn't be able to serve a Section 21 notice until you had returned the deposit, or in the case if you haven't provided the statutory information, you provide the information, correct the issue there. Section 21 going away, it used to be that you would rely on Section 8, and if you had grounds under Section 8, it didn't matter that you hadn't protected the deposit, you could still serve that notice. That's not going to be the case anymore. So you're not going to be able to use Section 8 as a fallback if you haven't properly protected the deposit. It doesn't, of course, mean that you can't return the deposit to the tenant and then serve a Section 8 notice, but it's something to be alive to, something certainly for landlords.
As a letting agent of 18 years, I didn't know that was the case even now.
Really?
I didn't know you could get away with not doing your job properly and still serve a Section 8.
You could serve a Section 8
I genuinely
notice.
didn't know that.
Yeah. So if a tenant doesn't pay their...
Not that I haven't done my job properly. All my deposits are registered. But I know a big company with a certain advertising brand who got big problems this year for not registering the deposits properly.
You've still got to have a ground 8 notice, a Section 8 ground to rely upon to serve a Section 8 notice. But if, say, for example, the tenant's not paying their rent and they haven't for a considerable period of time, and you can make out grounds 8, 10 and 11, you can serve a Section 8 notice even though you haven't properly registered a deposit.
That's new. New to me.
Not new.
Well, not new, but new to me.
Well, it's going to...
I knew.
Well, that's going to be done away with now. That's
anyway, we did know it. No.
That's irrelevant. Section 21 going. They have to make sure that they've obviously invested a lot of time and energy in leveling the playing field and bringing in all of these.
I think that's perfectly fair, though. I don't see anything in that list that doesn't actually, for once, make sense.
Yeah. Right. So those are the main things that I've picked out of the draft legislation. There's a lot more in there. If anyone is interested in looking at it, you can easily Google it. You can easily find the Renters Reform Act draft bill. And of course, if anyone listening out there in podcast land has any questions, I'd be more than happy to answer them. If anyone thinks we haven't covered something today that it's a burning question they'd like to have in their mind, or obviously contact Avocado if you've got any questions in the first instance, because you may well have the answer.
We'll put all of the contact details obviously in the YouTube and the podcast show notes as well. So if you do want to speak to Liam and get more information on, because everyone's circumstance is going to be individual, so it's much easier to have a conversation with a circumstance, a case study, than it is obviously the wider audience. So I think it'd be logical if people do want to know more. So yeah, absolutely. I massively appreciate you putting the time and effort into summarizing what is a very complex paper to actually digest at the best of times or at any time. And I think people will have taken a lot from that. And I think what comes next is a consistent rollout from us, constantly in communication to just keep people updated. So, at the moment it is a little bit of a grey area.
It really is. What we've got now may not be what we end up with.
Yeah.
So we just have to keep an eye on it.
But you have to plan ahead. I think that's the key thing. We've always mentioned that when you're investing in property, you're investing because you've got a goal in mind. If this is going to change your goal, you might need to pivot and change how you're looking after your property, what your plan of action is, how the finance is set up, and maybe the strategy as well. So it's a really good thing to be on top of early.
Absolutely is.
Because sometimes, you can't just go drop of a hat and change everything to make it work. So thank you for coming on.
Yeah, you're welcome. Thanks for having me.
Why have we made the Investors Corner podcast, Ian?
I think online at the moment there is just way too much noise, waffle and nonsense. Everyone's got an agenda. So the goal was to make a podcast for people that want to invest money in property or other areas where there's no waffle, there's no nonsense, there's no agenda. It's opinion led, but it's an honest opinion. And it might not be the right answer, but we're going to share it.
So on the podcast, we're going to supply people with access to mortgage brokers, financial advisors, planning experts, development consultants, everything around the property industry and the wider fields.
Yeah, so if you're looking at investing in the future, you know that just having an income from your employer or from your business is not enough to give you the life that you want down the line. We're going to hopefully give you some of those answers that will give you the solutions you need for the future.
So please hit the subscribe button. The more subscribers we get, the better guests that we can get on and the more people that we can reach. So hit subscribe.